All right, everyone, let's dive into one of the most critical and, honestly, one of the most debated parts of our constitutional law syllabus, the emergency provisions. You can think of these as the Constitution's ultimate fail-safe. It's emergency brake, if you will. It's a system designed to protect the very existence of the Indian state when it's facing its most dire moments. Getting a grip on this unit is absolutely essential, not just for your exams, but for truly understanding how state power operates in India. So this really gets to the heart of the challenge our Constitution's framers were up against. I mean, how do you design a democracy that can also handle a total worst-case scenario? They knew the nation could face incredible threats, things like foreign invasions or major internal uprisings that could literally tear the country apart. So they had to figure out, how do we build in the strength to survive a crisis like that without completely destroying the democratic soul of the nation? And their answer, well, we find it in Part 18 of the Constitution. So where do we find this plan? Well, you'll want to turn to Articles 352 to 360. This section basically lays out a detailed crisis management plan. It's a set of really extraordinary powers that are handed over to the Union government, and the primary objective here, is to give the state the muscle it needs to navigate a crisis and protect the nation's sovereignty and integrity. Now, before we can really get what happens during an emergency, you've got to understand how things work on a normal day. India isn't purely federal like the US, and it's not purely unitary like the UK. It's this unique hybrid system that we call quasi-federal. In normal times, power is shared between the center and the states. But, and this is key, that balance is designed to be flexible. And bam, this is where the whole game changes. The moment an emergency is declared, the entire character of the government shifts, and it shifts dramatically. That quasi-federal structure, with its careful division of powers, effectively transforms into a unitary system. All power gets sucked up to the center, right to the Union government. So the Constitution doesn't just have one big red button. It's actually got 3 different fail-safes, each one designed for a specific kind of crisis. As you can see, we have the national emergency under Article 352, the state emergency, which you've probably heard called President's Rule, under Article 356, and finally, the financial emergency under Article 360. We're going to break down each one of these, starting with the big one, the national emergency. Okay, let's tackle the most serious type first, the national emergency under Article 352. This can be declared when there's a grave threat to the security of India or any part of it. When this happens, the central government is granted these immense, sweeping powers to deal with the crisis head-on. Now, this is super important, so I want you all to really lock this in. The president can't just declare an emergency on a whim. The grounds are spelled out very clearly: war, external aggression, or armed rebellion. And pay very close attention to that note on the slide. The term armed rebellion is a huge deal. It was put in by the 44th Amendment in 1978, and it replaced the original, much vaguer phrase, internal disturbance. This change was a direct result of the controversial 1975 emergency, and it was meant to put a serious leash on the government's power to prevent it from being misused. So you might be thinking, has this ever actually happened? Oh yes, 3 times in fact. The first 2, in 62 and 71, were pretty clear-cut cases of external aggression, wars with China and Pakistan. But the third one, in 1975, that's the one that's still debated today. It was declared on those now-removed grounds of internal disturbance, and it was widely seen as a politically motivated power grab. That event led to massive criticism and, you guessed it, the constitutional amendment we just talked about. Okay, so we've covered the whole nation. Now let's zoom in a bit and talk about what happens when just one state is in crisis. This is where Article 356, what we all call President's Rule, comes into play. It's a mechanism for dealing with a breakdown of governance at the state level. The legal justification for imposing President's Rule is this key phrase, failure of constitutional machinery in a state. So what does that even mean? Well, think of it like this. It's when the state government simply can't function according to the Constitution anymore. Maybe it loses a no-confidence vote and no one else can form a government, or maybe there's a total breakdown of law and order. In those situations, the Union government can step in and take over the running of that state. But here's the thing. This is, without a doubt, one of the most controversial articles in the entire Constitution. As our source material puts it pretty bluntly, it has been frequently criticized for political misuse. The classic example that's always brought up is how it was used early on to dismiss the communist government in Kerala. This history has sparked a debate that's still raging today. Is Article 356 a necessary tool to keep constitutional order, or is it a political weapon for the central government to use against states run by opposition parties? All right, our third and final category. This one's all about the money. The framers learned from watching huge economic meltdowns around the world, and they wanted to make sure India had a tool to handle a severe financial collapse. And that tool is the financial emergency, under Article 360. And here's the wild part about Article 360, something that's really remarkable. It has never been used, not once in India's history. It's this incredibly powerful tool just sitting in the constitutional toolbox, held in reserve. A financial emergency could be declared if the president believes a situation exists that threatens the financial stability or the credit of India. So what would happen if it was used? Well, the changes would be massive. The union could basically tell any state what to do with its money. It could order pay cuts for all government officials, and that includes judges of the Supreme Court and high courts. Even money bills passed by state legislatures could be held up for the president's approval. The financial independence of the states would be seriously cut back. Okay, we looked at the what, the three types of emergencies. Now let's get to the so what. Let's put all the pieces together and really dig into the consequences. What does declaring an emergency actually do to the country, to federalism, and to our fundamental rights? This is the core of this unit. The first and biggest casualty, you could say, is federalism. As we've established, that quasi-federal structure completely flips and becomes unitary. In constitutional terms, this means Parliament suddenly gets the power to make laws on any subject on the state list, subjects that are normally the exclusive territory of the states. And on top of that, the union's executive power expands to give binding orders to any state. Okay, everyone, listen up, because this is probably the most critical takeaway for you as future lawyers, the impact on fundamental rights. During a national emergency, the 6 fundamental freedoms that we cherish under Article 19, like freedom of speech, freedom of assembly, they are automatically suspended, gone. But, and this is a hugely important but, thanks to the 44th Amendment, the rights under Article 20 and Article 21, which includes the right to life and personal liberty, can never be suspended. They are untouchable, even in a state of emergency. So you see the problem here, right? It's a classic balancing act, the central tension at the very heart of these emergency provisions. The whole justification is to preserve the nation, to give the state the power it needs to survive a genuine existential threat. But the concern, the huge risk, is the incredible potential for misuse, the danger that these extraordinary powers could be used to crush democracy, weaken the states, and stomp all over our fundamental rights. And that's the question I want to leave you with. Are these emergency provisions a necessary shield, an essential tool for protecting the republic in its darkest hour? Or are they a dangerous constitutional sword, one that, if it falls into the wrong hands, could strike at the very heart of the freedoms it's supposed to protect? This debate isn't just academic, it's absolutely central to understanding what kind of constitutional democracy India is and wants to be.